Good afternoon, it's Alex Woods here. I'm a financial irregularities specialist, a solicitor, and I'm bringing a number of claims on behalf of consumers that have also expanded in the past 18 months, 2 years into the insolvency sector, and I'm involved in realising PPI assets and enhancing IVA supervisors, IVAs, as well as dealing with some bankruptcy. I wanted to just delve into why it is that there are a relatively big rump of small and medium-sized insolvency practitioners who are not acting on the PPI crisis and are not attempting to realise the assets and are simply waiting for the guidelines to come through. And I think that there are a bunch of ostriches who've got their heads stuck in the sand and are hoping that the regulator is going to solve the problem for them and take away the headache of, which is, in fairness to insolvency practitioners, is a bit of a headache. Is it worthwhile the costs of setting up and administering and forming relationships with dodgy claims management companies and law firms for the purpose of realising PPI assets when you just don't know whether or not it's going to whether or not it's going to be cost effective, cost efficient. But nevertheless I am puzzled. I'm puzzled because I've been through I've got 3 IVA proposals, and I've been through 3 sample IVA proposals with medium and large insolvency practitioners, and I can't see why, at the very least, insolvency practitioners don't instruct a lawyer or a claims management company, or do it themselves, in doing an audit of the files in order to discover whether or not the PPI actually exists, and to try to assess some sort of level of quantum. So I hear that the creditors and the insolvency exchange have been pressurising and shoehorning insolvency practitioners with respect to their IVAs into pretty tight punishing deals. Perhaps the insolvency profession made hay whilst the sun shone 5 to 10 years ago in respect of IVAs, and now they're finding it more difficult. Nevertheless, I went through these 3 IVA proposals, and it seemed to me there was adequate room for manoeuvre for, at the very least, to be doing an audit of the files. So the first one I looked at was more of a traditional percentage. Percentage is a tradition. It's mentioned by the insolvency service. I mean, bankruptcies tend to be done by percentage of realisations. So I went through a typical one in which the IVA proposal referred to the 15% of realisations as their fee being 50% of realisations. A modification to be inserted here by the insolvency exchange that the insolvency practitioners, the IVA supervisors' fees should be equivalent to 15% of the realised assets. But in another part of the proposal, it's clearly stated that the 15% is an estimate of the supervisor's fees for the management of the IVA proposal. And I don't see why there isn't at the very least, room for charging typically £250, £100, £500, whatever it requires to have a lawyer, a Category 1 disbursement in respect of each IVA debtor's file to try and identify the existence of a missold financial product. The next one I went on to a big insolvency practitioner here. I probably shouldn't mention names for obvious reasons. Again, it talks about estimated fees should be paid. 2,000 should be paid with a balance available to creditors. Interestingly, in this clause it says it allows expenses and disbursements properly incurred, both external supplies of incidental expenses specifically identifiable to the IVA Category 1 disbursements, and other expenses and disbursements not capable of precise identification. It says that the supervisor is entitled to draw Category 1 or 2 out of the IVA proposal at the rates in the attached timesheets. tax schedules. So that's the second one, again talking about estimated fees that are going to be paid to the supervisor for running the IVA, and also clearly allowing for category 1 disbursements. Of course, category 1 disbursements, as far as my understanding of the way they're charged is concerned, you don't need to inform the creditors before charging them against the file. This is the third IVA proposal that I had a look at, and this one has an interesting clause. This is a slightly older 2006 IVA proposal, and the clause that it has says that the supervisor shall have regard to the complexity of the case and various matters, including the value and nature of the assets with which the supervisor has to deal. So there it is. I'm puzzled by I'm puzzled by the fact that the insolvency practitioners, I know the big players are realising payment protection insurance assets, and I also have it on reliable information on reliable authority that they are charging around about £250 to the file to do an audit. So a guy goes in. You see, I was down at Brighton a couple of weeks ago, and I went down to copy a file for some documents for one of the insolvency practitioners' debtor clients, and I was there for an hour going through the papers and I thought I couldn't understand why, you know, a fellow professional insolvency practitioner wouldn't be charging that to the file. Maybe they were charging it to the file, but then having me done the work of copying or scanning that file, there's then the second step, which is to actually do a proper audit, where it goes back to the law firm, the claims management company, and they write to the banks. And the big problem for the insolvency practitioner is the information is so scant, and on bankruptcies it's virtually non-existent. So there's a little bit of ferreting that has to be done by somebody in order to I mean, insolvency practitioners must be very familiar with having to ferret in order to realise assets. So a little ferreting needs to be done, and I don't see why, you know, fixed fees and ticks aside, insolvency practitioners today or last month or last year weren't getting someone in to audit all of their files and to tell that person, tell us and what's your estimate of the total value of payment protection insurance and other related financial products on the debtor's file, quantity and the total value. Now, I you know, this isn't terribly commercially sensitive. There is about 3.2 payment protection insurance claims per debtor file of around about 1,800. I was talking to someone the other day who said 2,500, 6.8, because the bank doesn't tell you about the PPI on consolidated loans, because each time the loan is consolidated, PPI is stuck on. They'll only tell you about the most recent payment protection insurance. Credit cards, unless you get hold of the statements, and so often I say so often, but I've seen plenty of credit cards where payment protection insurance has been stuck on the credit card completely without the client's knowledge. So, and you won't have the statements in the debtor file. You're probably lucky if you've got the original agreement. You've probably got neither. So you need someone to go away and do that ferreting. And as far as credit cards are concerned, you know, this is quite a high value item. I mean, I think IVA supervisors need to take this seriously. I've been litigating credit card claims. I did one against MBNA a couple of years ago now, and you know, we went from no F off, you can't, the client asked for it over a telephone call, to an offer of £3,000, to the court to a settlement figure of £7,000, and that was a tiny bit of PPI. The claims that I've been issuing or about to issue recently, we're talking about £20,000 or £30,000 because of the effect of compound interest, the true loss to the debtor client of having had PPI on their credit card for a great number of years before they were forced to go to an insolvency practitioner for help. So what I'm saying is there's quite, I think, a rich vein, if you like, of asset in each and every IVA debtor's file. Now I just want to conclude by, and indeed the other thing is I've got some stats on for my own company on PPI, and I'm looking at, this is an email that was sent to me today, the total of 55,000 offers across 15 debtor clients across a number of different banks. The names of the banks aren't listed. So that's I think that data speaks for itself. I just wanted to also mention that well, it was quite interesting that in terms of the R3 standard terms and conditions and the IVA protocol, the 2008 standard terms and conditions, what do they have to say about charging fees, disbursements, etc., in respect of IVAs? And surprise, surprise, the 2008 terms and conditions are absolutely silent on the issue. But there's still plenty of IVAs that were signed off under the R3 standard terms and conditions. And section 17.3 I found quite interesting. If the supervisor is dissatisfied with the determination of the creditors committee or a meeting of creditors on a matter involving his fees, costs, charges and or expenses, he shall have the right to refer the matter to the court, whose decision on the matter shall bind the parties. So I'm just wondering whether or not the small and medium insolvency practitioners haven't got the mustard to sort of what's the word, rattle the cage isn't the correct expression, but to redress the balance of the time when IVAs was something of a money go round, to the swinging 180 degrees with the insolvency exchange telling you that you can't charge more than £1,500 for a supervisor's fee. If you can't reach, I don't know whether small and medium-sized IPs are paralysed by the fear of the shadow of the creditors, cast over an IVA over 5 years or what, but there seems to be plenty of wiggle room in at least of those 3 IVAs that I've looked at for IPs to get out there and to start getting someone in to audit their files whilst they wait for the guidelines to come through. And really, I also don't see why they shouldn't be starting to instruct law firms or claims management companies or doing it in-house to realise these assets before the guidelines are published. So that's all for today, and please do leave any comments you think are relevant. I want to sort of open up this subject, and please do post any comments, particularly where you disagree with me, so that I can learn from my mistakes, as I imagine that the last 5 minutes have exposed a profound ignorance of the subject.